The House Committee on Natural Resources, Environment, Tourism, and Outdoor Recreation will come to order. Will the clerk please take the attendance?
Chair Pohutsky.
Here.
Representatives Hill.
Here.
Arvitt.
Here.
McFall.
Here.
Pies.
Present.
Martin.
Here.
Preston.
Here.
Shriver.
Here.
Madam Chair, you have a quorum.
Thank you very much. Representative Pies moves to approve the minutes from the previous meeting on January 18th. Hearing no objection, the minutes are approved. Today we're going to be taking up testimony on Senate Bills 393 and 394. They're sponsored by Senator Bayer, who is currently on her way over from wrapping up votes, so we're going to do things a little bit out of order. And at this point in time, I'm going to ask that the Department of Environment, Great Lakes and Energy, Sydney Hart, their legislative liaison, and Deputy Director James Clift come up and tell us a little bit about these bills. Thank you.
Good morning, Chair Pohutsky, members of the committee. Thank you for the opportunity to testify on Senate Bills 393 and 394. I'm Sydney Hart, Legislative Liaison for the Department of Environment, Great Lakes, and Energy, and here with me today I have our Deputy Director, James Clift. I want to thank Senator Bayer for her introduction of these measures. We're here to support Senate Bills 393 and 394, which would abolish the Environmental Permit Review Commission and the now defunct Environmental Science Advisory Board. I'll start by briefly touching on the Science Advisory Board since I suspect others won't discuss it today. The ESAB was short-lived, being enacted into statute in 2018 and abolished by Governor Whitmer in early 2019 through Executive Order 2019-6. It had a very specific task regarding water quality standards, which it completed prior to being eliminated. Senate Bill 393 is merely a cleanup bill that removes the now obsolete statutory language, creating the ESAB from our books. Now, for the Environmental Permit Review Commission. Overall, the department's position is that this panel results in a significant commitment of resources by the department, which slows down our overall permitting program but fails to add value to the process. I'm going to talk for a few moments about the resource commitment, then James will speak to a few of the impacts and values on the department's decision making. It's difficult to estimate the numbers of hours that have been dedicated to the establishment and the operations of the EPRC. Each petition may take 100 hours or more between time spent coordinating logistics, preparing briefing materials and presentations, hosting and participating in hearings, and facilitating the panel's decision-making process. This has a very real impact. Not only do we have a team dedicated to facilitating this panel's operation, along with the Environmental Rule Review Committee, but the programmatic staff that participate are stopping work on processing other permits, following up in enforcement cases, and assisting the public to prepare for and attend these hearings. And the same goes for the members of the committee. They have donated countless hours to the state in reviewing background materials, holding hearings on each of the petitions, and preparing decision documents. Some of the hearings span multiple days of testimony and presentation. We appreciate their contribution, but we do not believe the efforts and have added significant value to the decision-making process. Spending all of this time committing all of these resources and delaying ultimate decisions by months could make sense, but only if this work added value to the decision-making process. I am now going to turn it over to James to talk about the impact and value the EPRC has had on the department's decision-making.
Good morning, committee members. I appreciate the opportunity to talk to you today. I'll limit my comments to the Environmental Permit Review Committee. In general, the department's experience is that that it has served very little value to the department of having these committees here. Unfortunately, slowing down our permitting time, but really no meaningful difference in the decisions that the departments have made. And it's not the fault of the panel members. They have been great. But it's kind of a design defect. The law that was created has them almost set up to fail in that it's kind of a little ambiguous in areas. But what the worst part about it is it asks them to make decisions in areas that they are not experts. So it really kind of gets them beyond their scope of expertise. So I'm going to talk about the two different places where the panel currently operates, and how their kind of experience comes to play there. So the first set are pre-decisional appeals. So a permit applicant can come into the department prior to us making any decision on their permit and have this panel impaneled to kind of review their file, their application. So what happens a lot of times is they've come in with an application, and we work with a lot of the applicants. You know, the application that comes in doesn't either meet the statute or they haven't kind of fully considered all the ramifications. So we'll work with them and say, well, your application, that's not permittable, but if you make these changes, we think that would then comply with the law and we would be able to permit that. Well, sometimes when they start to hear that feedback, they had it in their mind what they wanted, you know, and if that's not what they're going to get, all of a sudden they're filing one of these pre-decisional appeals with us. Again, we've just been kind of working back and forth with the applicant, trying to get something that meets the law, but we've been unsuccessful. In the vast majority of those cases, what the panel does is it's looked at it, has said, well, it looks like the department is doing what they're required to do under statute. It looks like they're trying to kind of work with the applicant. And the panel decisions kind of read, and you should continue to do so. Work with the applicant, see if you could work something out, but it appears that you've been kind of following the law and trying to apply it fairly. That's been the vast majority of the decisions that have come down in that grouping. The second grouping are ones that are post-administrative law judge decision. So we've issued a permit. The applicant doesn't like it, or an interested party that's not the applicant doesn't like our decision. They've asked for a contested case hearing. It's went through the contested case process, which of course usually means that they've retained lawyers, they've provided all sorts of kind of testimony, they've briefed the case. Administrative law judges made the decision. They don't like the decision that the administrative law judge made, so they then can appeal that, and we impanel a 3-person panel to review that. The vast majority of those kind of ends up being more legal issues than they are kind of factual issues. So if it's a factual issue, you know, and it might have to do, let's say, with a wetland case. Well, our panel members may not be experts in wetlands. They could be experts in other areas. You know, we've got a few of them that are wetland kind of experts, but not, again, not enough to make every panel kind of match kind of the issue that's being involved. The vast majority, though, it's legal issues. And according to the statute, none of our panel members are lawyers. So they are then asked to make kind of a legal determination and overrule an administrative law judge in this case. So they have struggled with those decisions mightily. And it's important to remember that once they make a decision, once the panel makes a decision, that becomes the final decision of the department. Then the applicant or another interested party can challenge that decision to circuit court. That doesn't change. So they're still going to have their day in court, but in that case, it's a circuit court judge who does know the law and can make those determinations on whether or not we had properly kind of enforced the statute. So again, we've got a couple of different cases there where, unfortunately, some of them are just come in too early in the process. We really haven't even made a decision yet. Then the ones that have come later, they're more legal in nature, and therefore we don't kind of, the panel members feel like they're out of their area of expertise and not good. And we'll hear at least from one of those later this morning. So we appreciate the opportunity to talk to you today and willing to address any questions you might have.
Thank you. Can either of you say, since this law went into effect, roughly how many appeals have been filed with the Permit Review Commission?
Roughly, we've got, and again, this has probably changed, I think this is a little dated, around 40 in the pre-decision category, and around 15 in the post-ALJ category. About maybe a quarter of them, they determined to be ineligible for some reason from this process in general. The statute's very specific about who can apply and when, and they didn't qualify. But then the rest of them went through, panels were put together and decisions were made.
Okay. Are there other questions from any members? No? All right. Thank you both very much. I appreciate it. I saw Senator Baer make it over, so if you would like to come on up. Absolutely, the floor is yours.
Getting here today. Mike's not on, thank you. Good motioning. I've obviously just had great testimony, so I'm not going to go through everything. I wanted to mention a couple of things. This came our way. I come out of large corporate environments, and I've been on a little bit of a mission to kind of try to prove process wherever we can. So we've been working. Here is a good opportunity. Mishta, we've been working in a number of departments on streamlining some things that are just flat out overhead. And so that's how we saw this opportunity as a way to speed things up, eliminate some of the time that people are waiting to do things that are pretty important. So these two bills align with, we started with 4826 as well, which you already heard and passed through and is actually has a hearing in our house today, I think. So nice that they're moving along together. So, and you know that the Science Advisory Work Group doesn't even do anything anymore. They closed, and we heard a lot of detail on the Environmental Permit Review Board. So what I did was invite actually a friend, but also a former constituent of mine to come in. She's been a member of the Environmental Review Board for a long time and can give you that direct firsthand experience. So I'd like to introduce you to Emily Duthan. She is a geologist, renowned geologist actually. Doesn't know a lot, well, she does know a lot about water, but she's a geologist, just to say, to the point that we just heard from the Eagle folks, who are the people on the committees and what do they actually experience and the value they see. So, Emily.
Thank you. Can you hear me? Okay. Thank you for the opportunity to share my experiences as a member of the Environmental Permit Review Commission. My name is Emily Kaur Duthan. I was appointed to the Environmental Panel Review Commission in 2020. I've served on 10 review panels, including chairing several panels. 4 of the review panels were for contested cases in which petitioners appealed to the EPRC after Eagle has denied their permit. I've also served on 6 permit application appeals in which petitioners appeal to the EPRC before Eagle has completed their review. Many of those were incomplete applications that were submitted to Eagle. As a member of EPRC, I urge you to support the Senate Bills 393 and 394 and their equivalent in the House, and abolish the Environmental Permit Review Commission for 4 reasons. The EPRC process delays the permit application. It is not good governance. It's an expensive use of taxpayer funds, and it adds government redundancy, which contributes little or no value. So let me go into those. In the first type of appeal, permit application appeals, petitioners appeal to EPRC before providing complete information or allowing Eagle to respond to public comments and complete their review. For example, in one panel I was on, the petitioner appealed to EPRC the day public comments closed, giving Eagle no time to respond. When petitioners ask EPRC panels to rule on incomplete applications, the EPRC process simply delays the application. Number 2, in the second type of appeal, contested cases, panel members are sometimes required to rule on matters beyond their qualifications. Panel members are qualified in their technical fields, but may be asked to rule on matters of law beyond their expertise. As Senator Bayer said, I'm a geologist, yet one EPRC panel required that I second-guess a judge on a question of land ownership. The whole permit hinged on a question of who owned the land. The EPRC process empowered the panel to overrule an administrative law judge and staff attorneys on matters of law. This is not good governance. I'm not qualified to rule on matters of land ownership. EPRC panels are an expensive use of taxpayer funds. Each EPRC meeting includes typically 7 staff from Eagle and the Michigan Office of Administrative Hearings and Rules, including senior agency staff and an attorney. It takes time for staff to compile up to 10,000 pages. I've had some 10,000 pages of administrative records to review. It takes panel members who are volunteers a lot of time to read that. I'll vouch for that. EPRC staff find it difficult to fill panels with volunteer members who can review this volume of records within the statutory time constraints. These meetings are an expensive use of taxpayer funds, and each contested case entails 2 or 3 meetings. Despite this high cost to the taxpayer, it costs petitioners nothing to appeal to EPRC. And finally, EPRC panels are government redundancy which add little or no value. Contested cases go through the local EGLE permit staff, permit supervisor, their district supervisor, EGLE staff in Lansing, sometimes other state and federal departments, such as the Michigan Department of Natural Resources, the Army Corps of Engineers, the U.S. Environmental Protection Agency, and an administrative law judge. Yet 3 EPRC panel members are empowered to overrule this process, potentially overturning years of review by EGLE and a judge. Unlike EGLE staff, panel members have not seen the site and cannot be as familiar with the issues as EGLE staff, who may have spent years working with the petitioners. Because EGLE approves 99% of the permit applications it receives, only the most egregious permit applications are denied. All the EPRC panels I have served on have concluded that EGLE appropriately met its statutory mission to protect our environment and public health. So in summary, based on my professional experience and my service on the EPRC, please support these bills to abolish the Environmental Permit Review Commission, the Environmental Rules Review Commission, and the Science Advisory Board. These bills will streamline the EGLE regulatory and permit process, spend taxpayer funds wisely, eliminate government redundancy, and ensure good governance. Thank you.
Thank you very much. Does anyone have any questions for the senator? Okay.
Thank you, Madam Chair. Good morning, Senator. Some of the questions I have come up recently with some bills requesting EGLE to be able to promulgate their rules, and we're getting rid of a commission. I'm trying to prove a negative here because we have no good example of what has been delayed or slowed down. As a matter of fact, the one from the House bills, the example was during COVID, it was delayed and slowed down. But I go back to like James Madison talking about why the Senate is slow, and it's to be deliberative and remove passion from decision making. And I think the commission, trying to prove a negative here, just creates a fence there that rule making and decision making for the environment is made with the thought that it would be filtered with that commission, so only good rules are being promulgated. You remove that fence and you give them ability to promulgate the rules. I'm concerned that we give up our oversight ability and passions of administrations could take effect.
I do just want to flag, we're not taking up the bills on promulgating rules today. So those questions are probably best reserved for the sponsor of that bill or, you know, the people who testified to that. But if there's anything that you wanted to add to that, and I have a follow-up question as well, so.
Yeah, I think that even in listening to the testimony on the permit committee, we hear lots of cases where things are delayed. I mean, it really does add overhead to the system. And even speaking with someone who's been on the permit review committee for a long time, they've never changed, they've never disagreed with EGLE, they don't add any value. We're not really making anything better by having it. We're just causing everyone, not just the department and the volunteers and all the cost, but the people that are trying to get permits to get work done, having to delay and delay and delay. And that's a complaint we get all the time in construction and road work and, all of it. It impacts all kinds of projects. So if there was evidence that it was doing good, then yeah, maybe, but there isn't any.
And the follow-up question that I had is actually for Emily. You touched on this, but can you put a finer point on about how long is the process before an appeal even gets to you, the process with EGLE? You mentioned this briefly, but can you expand on it?
Depends on whether it's a appeal or a review of a completed permit. For the completed permits, it's usually years before it gets to the panel because it goes through the entire process from the local EGLE office through their supervisors all the way through an administrative law judge. I think we're talking usually 2 years or so. For the appeals, that could happen at any time, and I've seen some that happen fairly quickly and some that go, fairly on down the process. That's quite variable.
Thank you. Are there additional questions right now? right, thank you both very much.
Thank you.
Next up, testifying in support of the bill is Tim Minotis from the Sierra Club of Michigan.
Thank you. Pretty much everything I was going to say has been iterated already, so I will just, keep it brief and short. Tim Minotis, I'm the Deputy Legislative and Political Director for the Sierra Club here in Michigan, and on behalf of our 150,000 members and supporters here, we are supportive of Senate Bills 393 and 394. To kind of hit a finer point too on the delay process real quickly, I mean, once an appeal is submitted, really all processing of the permit is stopped. And so that only further delays and, really and Eagle can correct me, over 90% of the permits are approved. And so, and as we heard, the ERPC confirms Eagle's positions almost every time. And so to not further belay the points that were already made, we agree, the commissions are unnecessary. They do not provide a benefit to the people of Michigan in terms of protecting public health and our environment and our waste of taxpayer dollars. And the people on the panel are not equipped with the legal expertise to make the decisions for the state. Instead, what we should be doing is using the wasted financial and staff resources to ensure that we are equipping the department with the authority, the funding, the tools, and staff capacity to prioritize and protect our environment and public health here in Michigan. So happy to answer any questions.
Are there any questions for Tim? Vice Chair Hill?
Thank you. I don't know if you're the right person to ask this, but I was kind of waiting for this to come up, and it hasn't come up yet, which has been there's a lot of concern about unaccountable. People are somehow unaccountable who are making the decisions as opposed to elected officials. This panel, which is doing 99% of what Eagle wants, from what I hear, is there no appeals process here, or is there any accountability built into this process at all?
I don't know if I'm the best to answer that. This is, again, an unelected body that, from our point of view, and not just on the permit review committee, but also from the rules review committee, we found it historically to be very industry heavy. And so, there is the concern from our end with these panels historically, not to say that, they have agreed with Eagle and we haven't necessarily seen any problems, but hypothetically, and theoretically, we are having industry officials making decisions on permits that affect the industries that they represent. And I will say from our point of view, that is a concern that we have had with these commissions. In terms of further accountability, I'll let the department, speak on that, but I will say from our point of view, that has always been a concern from accountability point of view of having the fox guarding the hen house, essentially, I would say.
Any further questions? Okay, thank you very much for your time, Tim. We do have some cards to read in. Not wishing to speak and opposing the bill, Sam Boomis from the Michigan Aquatic Managers Association. Not wishing to speak in opposition, Tim Langholz from NFIB. Not wishing to speak in opposition, Ben Terrell from the Michigan Farm Bureau. Not wishing to speak in opposition, Jason Hayes from the Mackinac Center for Public Policy. Not wishing to speak in support of the bills, Megan Tinsley from the Michigan Environmental Council. Horst Schmidt, who is a private citizen. Chris Semerick from the Michigan League of Conservation Voters. Evan Zimmerman from the Upper Peninsula Environmental Coalition. Melissa DeSimone from the Michigan Lakes and Streams Association, and Liz Kirkwood of For Love of Water. Seeing no absent members and no further business before the committee will stand adjourned.